The next case on the call of the docket this morning is agenda number 6, case number 126715, People of the State of Illinois versus Tiquan R. Fane. Mr. Garson Fisher.
Good morning, Your Honors. Counselor, may it please the Court, Assistant Attorney General Garson Fisher for the people. Your Honors, defendant and Dreen McGee were convicted of breaking into the home of their 92-year-old victim and assaulting and robbing her. At the defendant's trial, McGee, who had already pleaded guilty and been sentenced for the crime, testified that he committed the crime with someone other than defendant. And the question here is whether the trial court abused its discretion when it instructed the jury to treat that accomplice testimony with great care, to carefully examine the accomplice witness testimony. Nearly a century ago, this court recognized that while we usually think of accomplices as a criminal pointing his finger at a fellow criminal, in fact, an accomplice is anyone associated with another in the commission of a crime, and it held that there is no reason to treat accomplice testimony less carefully based on whether the accomplice testifies to the state or the defendant's benefit. The court reaffirmed those principles in Rivera, and indeed, the committee notes to pattern jury instruction 3.17 say, based on Rivera, they recommend that the accomplice witness instruction be given regardless of whether the accomplice is testifying for the state or for the defense. But of course, the exact language of 3.17 doesn't apply in a case like this one, where the accomplice testifies that he committed the crime with someone other than the defendant. So the court gave its own slightly different accomplice witness instruction. But just because 3.17 doesn't apply as written doesn't mean that it was error for the court to give an accomplice witness instruction here. The question is whether the instruction that the court did give is sufficiently clear that it did not risk misleading the jury as to the law. Far from misleading the jury as to the law, it comported well with the direction, the holding of this court in Rivera and Toohey, that accomplice witness instruction should be carefully examined regardless of whether they testify for the state or, as in this case, testify to the defendant's benefit. And this makes perfect sense. Certainly, to be sure, an accomplice who testifies for the state has the unique potential bias of testifying so as to curry favor from the state. But as courts have recognized, an accomplice who testifies for the defense also has the unique potential bias of testifying so as to swear their accomplice and usually friend or close acquaintance out of the charges against them. This case is a perfect example. Dreen McGee, having already pleaded guilty and been sentenced for the crime, might well have had the bias of wanting to ensure that his longtime friend, they've been friends for nearly 2 decades. McGee testified that he considered defendant a cousin, of wanting to testify so as to ensure that his accomplice and friend didn't also get convicted for the crime that they had committed. So no, it was not an abuse of discretion for the trial court here to give an accomplice witness instruction where an accomplice testified to the defendant's benefit. But even if it was error, it's easy to see here that any such error was harmless. Beyond regardless of whether the instruction was given, the jury would have had good cause to carefully examine McGee's testimony and be deeply skeptical of it. Beyond their close relationship between McGee and the defendant, McGee's testimony was directly contradicted by other evidence at trial, and his story itself is essentially implausible.
Counsel, did you include harmless error as a contention in the PLA?
The state did not include harmless error as a contention in the PLA. Whether an error resulted in harm, such as reversible error, is inextricably intertwined with the question of whether reversible error occurred, as this court has held previously. So the court should still consider harmlessness despite the state's failure to include it in the petition for leave to appeal. As mentioned, McGee's testimony is hard to believe. He testifies that he and defendant's girlfriend were driving in defendant's girlfriend's car. They drop off defendant's girlfriend. Defendant then exits the vehicle and gives his girlfriend's car to McGee and this other person. And they part ways for long enough for McGee and this other person to drive to the scene of the crime, plan and execute the crime, and flee the scene of the crime. At which point, McGee is running across this grassy area towards the Prevena Hospital parking lot, where he just happens to see defendant hanging out in the hospital parking lot at 2 in the morning. It says, hey, and they meet up. And at this point, McGee hands defendant a T-shirt that he is holding. They see the police, they try and flee a little further, they get cornered and arrested, and defendant's holding this T-shirt. Now, besides the fact that this story of parting ways for exactly as long as it took to commit and flee the crime and then coming back together right before getting arrested being implausible, we have eyewitness testimony that McGee was not alone when he was fleeing across the grassy area to the west of the Prevena parking lot. We have no explanation for why McGee, who both the victim and police who saw him at the scene testified was not covering his face with a white T-shirt or anything else, would have been carrying this white T-shirt. What we do have is testimony that the other person who was with McGee was covering his face with a T-shirt exactly like the one that defendant is arrested holding in his hand 5 blocks and 5 minutes away from the scene of the crime. Moreover, defendant's girlfriend's car keys are found at the scene, and without any prompting from police questioning, defendant tells police that his girlfriend's car was stolen, which again contradicts McGee's testimony. So regardless of whether the jury had been instructed to carefully examine McGee's testimony, it would have had good cause to be highly skeptical of this testimony, and we can say with confidence that the outcome of the trial would have been the same regardless of whether the instruction was given or not.
In this case, as you indicate, the issue is credibility, correct?
Yes, Your Honor.
As you just described. And certainly the jury, I've not seen the record, but I assume the jury was instructed through other instructions about how to judge credibility of witnesses. Their motive, bias, and interest in the case, the reasonableness, I think specifically the instruction says, of their statement, their prior conviction for a felony. All of those factors the jury was told about in terms of the tools they should use to determine credibility, correct? And the IPI itself says that these issues about credibility, I think it's 3.0, talks about that the credibility being so important that there are some types of evidence that need additional instructions beyond the other instructions about how to determine credibility. And they sort of focus on some of them. And one of them is this idea that, and they don't use the word accomplice, that someone is taking the stand and is testifying about the crime. So how do we parse that out about what happened here in terms of what the jury found? The jury was instructed as to how to judge credibility in many, many different ways that certainly, I'm sure, were argued in closing argument. I'm sure the state argued you can't believe Mr. McGee for all of his valid, accepted principles of law. How do we parse out what is harmless error and what is not when we don't know? Did the jury not believe Mr. McGee because of the unreasonableness of what you've described, the fact he's has already been convicted of a crime, which we know is another basis for judging someone's credibility, or his motive, bias, and interest because of his relationship? How would we ever parse all that out?
Well, Your Honor, I mean, so the standard is whether we can say with confidence that the outcome of the case would have been, the trial would have been the same with or without the instruction. to the more practical question of how do you then apply that standard where you've got, you know, multiple instructions regarding the examination of evidence, and particularly the careful examination of the accomplice's testimony. It's similar to the examination that this court has to conduct whenever it's looking at a harmlessness question. It's going to have to take a look at the quality of the evidence of guilt and the possible impact of the alleged error, and make its determination about whether it can say with confidence that standard has been met. And I think here, this is actually a pretty easy case to do that, because as you mentioned, there are many valid reasons why McGee's testimony, to be skeptical of McGee's testimony, not specific to the fact that he might have this unique potential bias of wanting to swear his accomplice out of the charge against him. So the fact that his story is implausible, the fact that the eyewitness said that the defendant had, it's not McGee's accomplice, had his face covered with a white t-shirt that exactly matched the one that defendant was arrested holding in his hand above his head, that defendant was arrested with McGee mere blocks and minutes from the scene of the crime. McGee was identified both by the victim and by police. The fact that two people were seen running from the scene of the crime to the parking lot where McGee and defendant were arrested. All of this evidence is sufficient, particularly in the light of the fact that McGee's testimony is so suspect, with or without an accomplice witness instruction, to meet that standard of saying with confidence that the outcome of the case would have been the same, even if the jury was not instructed regarding the careful examination of accomplice testimony.
Of course, another factor the jury is instructed to consider in making credibility determinations is demeanor. And of course, we often say that that's really unreviewable. That's why we defer to jury decision-making. Here, not so much factual, but on credibility. I'm just not sure how we parse each one of these pieces out, or not.
I certainly understand Your Honor's point and Your Honor's concern. I don't think that the determination here is substantively different than the harmless error analysis that courts routinely conduct, where you are correct. We do defer to the trier of fact who saw the witness on the stand and saw them testify in many ways, and yet courts still are asked to engage in this admittedly challenging harmless error analysis in many contexts. And we know that the universe of structural errors that are immune from harmless error analysis is tiny, and for good reason. And so harmless error review is conducted in all kinds of contexts, including errors as to the evidentiary instructions at trial. And sometimes that harmless error analysis is going to be very close and very difficult, and sometimes, as is the case here, it's, I think, very clear that the error was harmless. But before even getting to harmlessness, it is also the case that this court has held that accomplice witness testimony should be carefully examined regardless of whether they testify for the state, which is the exact factual situation that 3.17 covers, or for the defense. And indeed, the committee notes added to 3.17 after Rivera reflect that. So on the basic question of whether the court abused its discretion in giving this instruction to carefully examine McGee's testimony because he was associated with defendant in the commission of the crime.
Counsel, that's what I wanted to ask you is, Why was the language in the jury pattern instruction changed from accomplice to witness? And who actually said he was involved in the commission of the crime with the defendant?
Well, he is.
Because you use both words, witness, accomplice, together all the time. So it was changed, though, wasn't it?
Well, I use the words accomplice, witness together to indicate that he is a witness who, through the justice system, has been associated with this defendant in the commission of this crime. We know that McGee has pleaded guilty to this crime, and we know that defendant has been charged with being the other person who committed the crime with him. He's now been convicted, but at the time of the testimony. And that is like the situations that are discussed in Toohey and Rivera, where you have a witness who's testifying that they did not commit the crime with the defendant, but they have been associated with each other in the commission of this crime through the judicial system. To be sure, in Rivera, it is true that the witness had previously told police that they had committed the crime together, and that is a factual distinction. But A, that was not the case in Toohey, and the court was clear that it was reaffirming the principles of Toohey in deciding Rivera. And B, that wasn't the testimony he gave at trial. At trial, he testified that he did not commit the defendant in Rivera did not commit the crime with him. So we have this holding from this court, both nearly a century ago and more recently, that whether or not the witness is saying, yes, we committed this crime together, that the idea of an accomplice is something broader than that. It's any time two people are associated together in the commission of a crime, which was this court's language from Toohey, reaffirmed in Rivera, and that there was no reason to treat an accomplice's testimony, to examine it less carefully just because he testified on defendant's behalf. And so then that gets added into the committee notes in IPI 3.17, but as noted, IPI 3.17 still reflects a situation where we're limited to this, perhaps what we more commonly think of when we think of accomplices, but which this court has held is only part of the group that constitutes accomplices, and only part of the group of witnesses that deserve this sort of special care and examination above and beyond the biases that indeed, any witness might have. Courts have recognized, both this court and numerous other courts around the country have recognized that accomplices, both testifying both for the state and the defendant, do offer a special class of potential bias above and beyond the usual considerations that juries give to the biases of all witnesses.
This isn't really an IPI case. And this really doesn't have to do with IPI because, the definition of an accomplice in 3.17, this doesn't fit that. And you say the trial court slightly changed the instruction. The trial court changed the definition of an accomplice. So it really takes it out of IPI and takes it into this Toohey, Rivera, when do we authorize a special instruction on this situation, correct?
Well, I think both parties agree 3.17 as written does not apply to this case. Absolutely.
So really, forget about IPI. It's really when is a special instruction given? And you say that this is one of those times where, trying to swear the client not guilty comes into play. Where do we draw the line on that? Do we give it special instructions for mothers who give alibis for their children now?
No, Your Honor, we shouldn't.
Well, that's somebody who really has a bias to swear their child not guilty.
I understood, and certainly there are cases that deal with, the impact of family bias on the credibility of witnesses and how much weight that evidence should be given and so on and so forth. But I think, the standard for giving a non-pattern instruction is abuse of discretion, which asks, was it clear enough that it did not risk confusing the jury about the law? And contrary to confusing the jury about the law, the pattern jury instruction that was given here does comply with the holdings and the language used in Toohey and Rivera. And the only reason I came back to the IPI, to 3.17, is that while the IPI does not apply to a case like this, the committee notes indicate a recognition that that Rivera did hold that an instruction about the special consideration that should be given, examination that should be done of an accomplice's testimony applied regardless of whether the accomplice was testifying on behalf of the state or the defendant. So applying that abuse of discretion standard, leaving 3.17 aside, because this is not a case where there was a pattern jury instruction on point and the court chose to deviate from it. Using that abuse of discretion for this non-pattern instruction.
Mr. Fisher.
Well, thank you, Your Honor, unless the court has any further questions.
Thank you. Mr. Miller?
Good morning, Your Honors. My name is Darren Miller, and I'm with the Office of the State Appellate Defender, and I represent the appellee Fane in this matter. Your Honors, the appellate court correctly found that the non-IPI accomplice instruction, which directed the jury to consider Mr. Fane's entire defense with caution and suspicion, was reversible error. What I think is important here is to kind of go through the IPI and the history, and I think has already been touched upon. The IPI requires implication. The IPI itself says when a witness says he was involved in the commission of a crime with the defendant, says he was involved in the commission of the crime. The counsel was referring to the committee notes, but that says this instruction is given in accordance with Rivera. And this instruction requires implication. And if you look at the history of what led up to Rivera, and putting Toohey aside for a moment, there were essentially two lines of cases in Illinois pre-Rivera. One line essentially said that you only can give this accomplice instruction if the accomplice is testifying for the state. And then the other line of cases said, well, no, you can also give it if the accomplice is testifying for the defense, but only if there's implication. So that's the history leading into Rivera. There were no line of cases that I'm aware of, and counsel certainly hasn't cited that, and he's saying that implication is not required. And that was the split going into Rivera. And in fact, Rivera itself involved implication. And Rivera,
I'm not sure I know what you mean by implication. What do you mean?
the accomplice basically accused the defendant was involved in the crime, implicated the defendant, which didn't occur here. This is the opposite.
In Rivera? Is that what happened in Rivera?
Yeah, there was substantive evidence from the accomplice's prior trial that was admitted that implicated the defendant in Rivera. And in Rivera, it was IPI 3.17, which this court held should have been given, and that itself requires implication by its own language.
I'm not sure I still understand your argument. I really want to make sure I do.
Sure.
In Rivera, the witness testified on the stand that he had committed the crime and that Mr. Rivera had not.
Correct.
And so the jury was instructed how to look at that testimony.
Yeah.
And how to judge the credibility of that kind of testimony. And this court said that in viewing, that the appropriate instruction to give was that the jury should look very closely, whatever the language is, subject to, the testimony of the witness is subject to suspicion and should be considered by you with caution. And so in that case, Mr. Rivera, this witness, this court said the jury was correct in being, it was correct to instruct that jury. Why isn't it the same thing that's happening here?
Well, 2 points. One, if that is the law, then they should have given 3.17 here, which they didn't. That's the instruction that was given in Rivera, was 3.17. But also in Rivera, that was a testimony at trial, but the accomplice's testimony at his own trial was admitted as substantive evidence, which did implicate the defendant in Rivera.
Why does that affect the analysis? We're talking about how the jury comes in, they're trying to do the right thing, the court is giving them tools to make a credibility decision. Look at the demeanor of the person. Look if they make prior inconsistent statements. Look if they've committed a crime. Look at their motive bias and motive. And an additional tool is look to see if they are an accomplice in the case. Why does any of that narrowly require this idea that you call implication?
Well, I think you have to look at the policy behind the rule. And case after case, I just jotted down Hunt, McLean, Jordan, Lewis, 2nd, 4th, 1st District, and even this court. The purpose why you tell instruct a jury to consider the testimony with caution and suspicion is because of the enormous power that the state has over an accomplice, that it's presumed that an accomplice is very likely to say whatever's necessary to get himself leniency. And that bias doesn't exist when there's no implication. In fact, it's the opposite. He's going against the state.
So that's a policy argument. The other policy argument that's been proposed is that the jury should be aware that this is more than just another witness. This is someone who has taken the unusual position of coming to court, admitting to a crime, and then making a statement that this defendant did not commit a crime. An unusual position. Why shouldn't the jury be aware of the dynamic in that kind of situation?
Well, Your Honor, it's an unusual situation, I guess you could say, but there's all kinds of biases that are in all kinds of cases. As one of the justices pointed out, a mother testifying for a child, lovers, friends, a lot of different biases. And there's only one jury instruction that even tells the jury how it's to treat that evidence, and that's 3.17, and says to treat with caution and suspicion. There's just no reason to depart from a general bias instruction because, as the state argued in its brief, there's a long-term relationship. Well, a long-term relationship, that's just a general bias. That's covered by the IPI. And as far as the swearing out, counsel conveniently omitted, it's the swearing each other out. So it's, there might be a different situation if Mr. McGee hadn't already pled guilty and he's hoping, well, gosh, maybe if I lie at Fane's trial, he'll come to my trial and lie. Well, he already pled guilty. So that bias just doesn't even exist in this case. Again, this accomplice instruction covers the law and it properly states the law, both pre and post Rivera. I hope I'm pronouncing the name right. Sadlowski, it's a 3rd District case, held implications required. A unanimous appellate court in this case held that implications still required after Rivera. And the 1st District case of Ticey also held unanimously that implications still required post-Rivera.
Counsel, you mentioned Tui. How do you distinguish this case?
Yes, Your Honor. Well, again, Tui's a 1935 case, 85 years old or whatever. And every case since then has required implication. Tui also involved, which was also the case in Rivera, you had accomplice witnesses testifying for the state and the defense. So it's kind of a unique situation in Tui where if you're going to, and in Rivera, where if you're going to say to take the state's accomplices with caution and suspicion, not the defense. You're kind of bolstering the testimony of the accomplice witnesses for the defense. As it was in my brief, Howard, it's a 1970 case from the 3rd District, rejected the state's argument that it has here. And it basically said the same thing, that TUI did not discuss the policy behind the accomplice instruction. Both sides had accomplices testifying, which isn't the case here. And TUI only considered the narrow objection by the defendant whether anyone can even be an accomplice when they testify for the defense. So, you know, TUI was a unique case. It has not been interpreted to get rid of the implication requirement, and case after case after case has required implication for good reason because of that unique power that the state has. And again, no other instruction directs a jury to consider with caution and suspicion except for this one.
Counsel, assuming that 3.17 should not have been given because what you're calling implication is inherent in the definition of the instruction, again, we consider this as basically a non-IPI. Now, I know you're taking issue with TUI and you're taking issue with Rivera, but is it an abuse of discretion to instruct the jury on the state of the law as it exists? I mean, you said TUI's very old, but in Rivera, this court made an unequivocal statement, we still adhere to TUI.
Well, again, I just didn't distinguish TUI because it's old. I mean,
Well, no.
but I'm sorry, I kind of lost track. What was your question, Your Honor?
No, my question is, if we're not going to worry about 3.17, why is this an abuse of discretion to, you know, you can take issue with TUI, you can take issue with Rivera, but they say what they say. Why isn't this a correct statement of the law based upon those statements?
And just simply because the non-IPI given here misstates the law, that implication is still required in Illinois, even in light of TUI, in light of Rivera. I mean, that's been going on since 1935, since TUI, and since 1994-ish, since Rivera.
Well, TUI didn't require implication for the one witness. I mean, the request was just to have the limiting instruction as to certain the state's witnesses, and the court approved it as to the exonerating witness too. So implication wasn't required as to that witness.
Yeah.
And if you look at Rivera, you know, really it's couched in terms of credibility and really focusing on the problems with this witness's credibility and whether it was an abuse of discretion to give that instruction based upon the issues with that witness's credibility.
Yeah, but Rivera did not overrule the line of cases, the extensive line of cases that require implication. And again, heading into Rivera, there was only a split. Can this instruction only be given to a state witness or defense witnesses who implicate? That was the line. And Rivera did not come out and say that implication doesn't matter, and nor should it have, because there's no good policy reason to switch from that. And if you're going to stray from the IPI, there should be good law behind it, and there is no good law behind it or good policy other than clinging on to certain language from both cases. And that language did not involve an evaluation of the policy behind this, and it did not involve this situation of giving completely exculpatory testimony.
So is that, I'm struggling with what the IPI does in terms of credibility. This is not a statement of the law in the sense of articulating the elements of a crime or something like this. This is what has been the policy in the state of Illinois, what is the status of the law and the policy about giving this instruction. Isn't that where we really are? Isn't that what this is about? Again, this sounds to me like very discretionary kind of call. Is it necessary in every case for a court to analyze the policy behind certain instructions before they give them to the jury?
No, I mean, my position is putting policy aside. You just don't, you give the instruction or you don't. And there's no good legal instruction that you can give when there's no implication. That's our position. Moving on to the harmless error. First, that's the state's burden, obviously, to prove that an error is harmless. We argued that that was forfeited by the state because the state did not raise harmless error in its PLA. I feel that that's basically a strategy that the state can use, is to keep harmless error out and to overstate how Rivera and TUI clearly control. And then once they get their foot in the door here, then it's arguing, as it did today, extensively arguing plain error. So I don't think that's something that should be taken advantage of by omitting plain error from the PLA. Regarding whether or not the error is harmless, you have to look at the strength of the state's case versus the seriousness of the error. I can hardly imagine error more serious than telling a jury to take the entire defense with caution and suspicion. McGee was essentially Mr. Fane's entire defense, and sure, the state could have argued that, but this is a court telling the jury to take the entire defense with caution and suspicion, and that's a very serious error. And then you take the state's case and the defense, and it's basically the credibility issue. It's, if you believe Mr. McGee, then Mr. Fane's not guilty. And the state essentially wants this court to stick its foot in and take over a jury determination, and that's just not correct. There were no confessions, no fingerprints, no eyewitness identification. So, you know, the appellate court unanimously found that this was not a harmless error, and I would ask this court to affirm that finding. If there are no other questions, we'd ask that you affirm the appellate court.
Thank you, Mr.
Thank you.
Mr. Fisher?
Thank you, Your Honors. As Your Honors noted, TUI can't really be distinguished on a substantively meaningful basis from this case. And in Rivera, the court was clear that it was reaffirming the holding and the reasoning of TUI. And the defendant points to the fact that there were accomplice witnesses on both sides in TUI, but in fact, defendant's position here is exactly that accomplice witnesses for the state should be carefully examined, whereas accomplice witnesses for the defense should not. And that's the principle that was rejected in TUI and reaffirmed in Rivera. And yes, there are lots of different kinds of biases, but this court and many other courts have recognized that the potential biases of accomplices, both for the state and for the defense, are different, and therefore that it is appropriate to instruct the jury to carefully examine that kind of testimony, regardless of on whose behalf the accomplice is testifying. The defendant points to several circuits that have come out sort of the other way and held that that an accomplice witness instruction is only appropriate for a state's accomplice. We can certainly do the same on the other side. The Seventh Circuit, the Fifth Circuit, the Ninth Circuit have all held that an accomplice witness's instruction is appropriate for a defendant's witness. And there are unpublished district court cases here in Illinois, which we don't cite to, obviously, because of the rules, although we noted it in a footnote in our reply brief in response to defendant's argument. But the really important point here is that there's nothing that a court from a different jurisdiction or that an appellate court in this state could say that would change the import of this court's holding in Tui and in Rivera. And so, no, it was not an abuse of discretion. It did not mislead the jury as to the law to instruct them to carefully examine McGee's testimony. It was in fact consistent with the law as stated by this court in Rivera and Tui, and that's the question that is being asked here. As Your Honor noted, this is not a situation where the instruction was answering a legal question. What are the elements of the crime? What does causation mean? What does reasonable doubt mean? This is not a case where there was an on-point IPI that the court decided not to use and go its own way. The court issued a non-pattern jury instruction that did not mislead the jury as to the law, so it was not an abuse of discretion for it to do so. And for that reason, or because, as we've argued, the error was harmless, this court should reverse the judgment of the appellate court and affirm defendant's conviction and sentence. Unless the court has any further questions.
Okay,
Thank you, Your Honors.
thank you. Case number 126715, People of the State of Illinois versus Fane, will be taken under advisement as agenda number 6. Thank you, Mr. Fisher, and also Mr. Miller, for your arguments this morning.